Welcome to Profiling in the Court. This is Pat Brown, and I'm coming to you tonight because I did watch the opening statements of the Derek Chauvin trial in the death of George Floyd. And I thought, after seeing a lot of the commentary coming out of the networks, that perhaps it would be a good idea to have someone truly focus on the evidence and not all the emotions and all kinds of political things. And, they're all over the place, but they're not focusing on the true issues. And that really concerns me because that's one of the problems we're having now with our court system, is that it's in the media. Everything's in the media, and it affects what happens in the court. So we're not having a trial that's just focused on the evidence. We have a trial that's pretty much got everything else. It's like a circus that's going on. And you hear commentary that's, wow. I mean, one woman on CNN said, well, George Floyd had other encounters with the police and didn't die. So therefore, this encounter, since he died, clearly says the police are at fault. Well, I'm going to get into the evidence later, but I mean, that's just a ridiculous statement. I mean, that has nothing to do with anything, and it is not logical. And you're on national TV saying that kind of stuff. But people are going, yeah, that's right. He's done drugs before, and he's encounters the police, and he never died. So clearly, this proves that Derek Chauvin is guilty of homicide, or guilty, even worse, of murder. And again, this is not focusing on the evidence. And so this is what I want to do in this next hour, is focus on the evidence. As a profiler, I love the fact that evidence is what is there for us. You take the emotions out of it, and what you have in front of you is their facts. Of course, you have to evaluate those facts. You have to make determinations based on facts. And that can go a little awry too, especially if it's a complicated case. And let me tell you, this is a complicated case. It's not as easy as people think. And this is going to bring up my first major point. And I have to go on my little bit of a soapbox here. I have an issue with the jury system. I know people think, hey, you don't want one of those judge systems that other countries have, where you just got three guys from the government and they say whether you're going to go to prison for life or not. You can't trust them. So I'd rather have a jury of my peers. But here's my problem with it. And it may have changed over the years from way back when it wasn't such a complicated issue in the court. There wasn't so much forensics. But let's say, for example, you have a rocket at NASA and there's problems with it. And there's something, I don't know anything about rockets, so I'm going to make this up. Oh, there's a problem with a rocket booster, if there is such a thing. And so what, normally you would think you would do is you'd get your scientists together and you would all work on the problem together, and you'd analyze it, and you bring everything to the table and you discuss it and go back and forth trying to figure out exactly what you should do. But imagine this. Imagine that instead of doing that, you said, we got to fix this rocket booster problem. So let's go out to the bus stop and get 12 people waiting for a bus, bring them in here, and we'll present two different groups of scientists, one that say we should do this and one that say we should do that. And then we'll let those 12 people from the bus stop figure out which one group of scientists is telling the truth. Now, mind you, the group of scientists are all Dr. somebody and Dr. somebody and Dr. somebody. And these people on the bus stop, they might be a doctor of medicine, or they might be a waitress, or they might be someone who works in a garden shop, or they might be a teacher, but they're not doctors of physics. They're not doctors of rocket science of any sort. They're regular people in other fields. They may be brilliant in other fields, but they don't know a damn thing about rockets or physics. So now, does this make any sense? So you put these 12 people in a room, and this group of scientists says, we ought to do A, B, and C. And this group of scientists says, no, we ought to do D, E, and F. And then after they present this group of 12 people has no clue which ones are telling the truth, kind of guesses, okay, I think they made a better argument, I think. Maybe they like their tone of voice. Maybe they like somebody's face. But they honestly do not understand the subject matter. And you would never do that. You would never think that was a wise way to make a decision. And here we are today in the courtroom with juries. Now, they go through lots of people, and then they pick them. Of course, the defense doesn't want anybody who's in, like, for example, a criminal profiler. I will never be on a jury, ever. Because the one time I went and they said, "What is your profession?" And I said, "I'm a criminal profiler." The next words were, "Thanked and excused." And I went away because the defense attorney didn't want me there. And so they're very carefully trying to select people they think will support their side, not the facts, not be able to analyze evidence, but to support their side. Now, first of all, we have to ask, how are these people getting onto the jury? Are they taking lie detector tests before they come on? Are they taking a polygraph to prove that what they're saying is true? Like, I've never seen anything about the George Floyd case. I never saw that video. I do or do not support Black Lives Matter. You know, they're going to say whatever they say, and it's not proven that what they're saying is the truth. So you have some very honorable people coming on. You have some very dishonorable people coming on. And there they are. You have a regular group of people, nice people maybe. Maybe they're, I say, good in their fields. But most of them, I'm going to say probably almost all 12 of them, do not know a thing about forensics. They do not know a thing about psychology. They do not know a thing about any of these things that are going to be included in the case, unless they watch, CSI or something. And that is what we call the CSI effect. Oh, I saw it on television, and that's how I know this is true. Oh, Lord. It just doesn't make a lot of sense. And here's what gets worse. Now the defense is going to put on its experts, and they're going to have experts that say A, B, and C. And then the prosecution puts on its experts who say D, E, and F. Well, if they're both experts in the field, they both support science. How come the two opinions are exactly the opposite? How is that even possible? Well, in my opinion, someone's probably telling the truth and someone got paid a lot of money. Hey, my opinion. But it seems odd to me that you can have two separate opinions on the same thing. Now you have the jury. What are they supposed to do? Because they've been told by experts two different things. Who are they supposed to believe when they themselves are not experts? And do you know, they have very strict rules about who can testify in court. And if they have that strict rules about who can testify, and these people who are testifying are here because they're not making the final decision, why would you have a jury over here with even less skills, less qualifications to make the decision over people who had to go through a lot to even be able to testify? And these people have no qualifications at all. Is something just not right about that? Okay, so that's the problem. That's my soapbox. But here's why I bring it up. Both the prosecution and the defense will use that to their advantage. They will present things that they know they can manipulate the jury with. And one of the things they do is use emotions. And emotions should have no part in a courtroom. Emotions should not be there because this is about evidence. It's not about your feelings. So I feel like that, that's probably me. I like the guy, or that was a bad thing to do. It has nothing to do with the law. But they're going to play on that. And there's so many examples of how that's being played on. And I'll bring that up as I go through what the prosecution is presenting and what the defense is presenting. And I've got my notes over here because I had to take a lot of notes. And so I want to make sure that I'm speaking correctly from the notes and pointing out the things I want to point out. So let's go to the prosecution. Right away, the prosecution said, oh, by the way, one more thing on the jury. They're not sequestered. I don't understand this. It's like the biggest case of the century. They're not sequestered. And the judge goes, when you go home, don't tell anybody anything. Don't have any chit chats. Hey, don't check your social media. Don't watch TV. Really? Okay. I mean, I thought that in a trial like this, they would be sequestered and their phones would be pulled away from them and there would be no TVs in the room. But no, they have access to everything. So they can see what the feelings are outside of the courtroom and what people are saying. And with this case, for an entire year, basically any jury has been prejudiced because there's so much politics involved in this. There's so much emotions going on. They've already been prejudiced by the protests and by the media and everything that just, regardless of what you think about anything, all of this has been coming into your brain. So that's already a problem coming into the court. Secondly, the trial is still in Minneapolis, which I think they should have moved the venue. But they got local people who are in a town that's just like a war zone almost, people going crazy. And then you just think, you're on that jury, and you know pretty much if you find Chauvin not guilty, all hell is going to break loose. Everybody knows that. And I'm not saying that they're going to make the decision based on that, but that certainly plays into, your fears and how you're going to be looked at the rest of your life. And if you live in the area, that you might be responsible for the whole town burning down if you happen to decide Chauvin is not guilty or one of the charges that they have on him. So all of these things are just, it's like a dynamite keg, and it's really kind of scary. So anyway, let's go to the prosecution. All right. One of the first things the prosecutor said was he starts giving this statement, and he says that Chauvin betrayed his badge. He used excessive force, put his knee on his neck, grinding and crushing him until the life was squeezed out of him. Okay, that's not supported particularly by evidence. That is an exaggeration, an emotional, plea by the prosecutor, because he wants people right away to see that Chauvin is absolutely using excessive force in a specific way that is indefensible. So he's starting out with that. And then he goes, and this one clever thing he did through this entire opening statement was he kept saying 9 minutes and 29 seconds of excessive force. 9 minutes and 29 seconds of excessive force. 9 minutes and 29 seconds of excessive force. He said that repeatedly because he wants that drilled into the brain of the jury. Again, we're not talking about specific evidence because there isn't proof of 9 minutes and 29 minutes of excessive force. There is a period of time, 9 minutes and 29 seconds, where he was being restrained. That's all we have proof of. And if you're going to say it was excessive force for the entire 9 minutes and 29 seconds, you better have something from the very beginning that he could not breathe from the minute he hit the ground, and it was being caused by Chauvin. So it's just it's a bit of an exaggeration, but he wants to drill that into the brain of the jury, and it was very effective. I personally thought, I have to say this right up front: prosecutor doing the type of jobs prosecutors do, and I'm not saying whether I approve of the way they do their jobs, but the prosecutor was excellent. He drilled home all the ideas he wanted to drill home. He put the video up from the minute Floyd hit the ground and Chauvin had his knee on his neck area, and he put that image straight into the mind of the jury. And then the defense attorney came out and he gave his statement, and quite frankly, I don't know if there were no other attorneys available that would take this case, but it was a very lackluster statement. It was basically like, y'all got to use, your common sense, and that's it. I'm like, that is not the best opening statement I've ever heard. So the defense attorney better have something he's planning to bring along, because it wasn't particularly good. All right, let's go back. There is a point where he says, he describes sort of the basic things about George Floyd being on the ground, and then and how much time goes by and how his breathing seems to have stopped and he's motionless. And then the paramedics show up, and then and then Chauvin finally gets off of him, and the paramedics load him into the ambulance, and he says all that. Okay, now, then he says something which he starts talking about the Minneapolis use of force policy standards. And this is called, you only do that which is objectionably reasonable, that is consistent with training. Objectively, I think I said that wrong. Only that which is objectively reasonable, that is consistent with training. In other words, when you've gone through training as a police officer, you have been taught what you should do. And you should be only doing what is reasonable. And objectively, and meaning not subjectively, like, I think that personally reasonable to me. No. If you had a whole bunch of police officers and a bunch of non-police officers, they would say, yeah, that makes sense that you should do that in the circumstances. So there is training that is given to all police officers. And the question is, and this might come out in the further part of the trial, what training, not how much, but exactly what training did Derek Chauvin get on this particular aspect of what happened, the use of force? How much training did he get? And when did he get it? And that's very important. People don't seem to understand that. Training is not sometimes as good as people think it is. Sometimes police departments don't have the money, they don't have the time, they can't spare the officers. So they get some training, but they don't always get all the training. Or if you've been on the force 17 years, you might have gotten that in the police academy. Okay, this is excessive for blah, blah, blah. And then the years go on and you haven't gotten refresher courses, or often enough, or maybe at all. I don't know yet. So we're going to find out. Hopefully we'll find out. Did Derek Chauvin get specific courses, specific training in the most recent rules and regulations and methodologies and safety procedures? Or are we talking about I haven't actually taken a course in like 5 years. The last time 5 years ago, this was cool. I don't know. We'll find that out further in the trial. But the prosecutor is right. There is, if you have to follow the training that you've been educated in, and if you veer way off of that and then put someone in danger, well, then that is your fault because you had the training. So we'll see what training he really had. Then he goes on to this is completely irrelevant, by the way. He goes on to claim that Floyd never admitted he passed a $20 bill. I think he actually did, and even if he did it on purpose, he should have let Floyd go on his way. What? I mean, first of all, if he committed a crime, he committed a crime. And when the police were called there, the people from the store were saying, Floyd was acting really freaky. Thought he was really drunk. He was out of control. So they went over to his car and knocked on the window, and he started acting really weird right there. They tried to get him to keep his hands up on the wheel, and he wouldn't do it. So, he kept dropping his hand, which could mean he has a weapon. So therefore, the police had to pull out a weapon, until he got his hands up there. And the prosecutor's saying, they should never have done any of that. Well, I'm sorry, but that's their job, to protect the community. And when crimes occur, they are to investigate them. And when they go to talk to somebody and they're acting completely weird, like they shouldn't be behind the wheel of the car. Like, so there was already said that he had fallen asleep behind the wheel of the car, and the woman that was with him was calling somebody to get a ride because she was like, hey, he can't even drive. Well, he's not supposed to be behind the wheel then. And besides which, he theoretically may have committed a crime. So the police had no option but to do what they're supposed to do. Just because, you just can't say, we just won't bother with him. Somebody called us, but we're not going to bother with him because we don't want anything tragic to happen 30 minutes from now. I mean, this is ridiculous. George Floyd had criminal behaviors in his past, and in the moment that this was going on, his behaviors were not legal. Let's put it that way. Let's say he didn't pass a $20 bill, which I think he did, because the store owner came out and said, hey, look, this is a fake bill. All we want you to do is give the cigarettes back or give me some money to replace this $20 bill. And Floyd wouldn't do it. And then when the police arrived, Floyd clearly was under the influence of something, which he was. He was under the influence of drugs, which is illegal. And he had drugs in his car, which is illegal. So he was committing crimes at the time the police arrived. So to say the police shouldn't have bothered him is outrageous. That, if the police hadn't bothered him, this wouldn't have happened. Well, I'm sorry, but if you don't commit crimes, you won't have the police bother you. So, I mean, that's just a ridiculous statement there. And then he went ahead and he showed, he said Floyd should never have been put on the ground down in handcuffs. Now, that is not necessarily so, because sometimes when you can't control a very large person on drugs, you sort of sometimes have no option but to get them in a position where you can manage them. Now, I'll go into that a little bit more, because there are issues with putting a person who is restrained in a prone position, especially a person who is on drugs and has what is called an agitated delirium, which he did exhibit. And I'll talk all about that in a little bit. But to say the police should never have restrained him is ridiculous. And that he should never have been down on the ground even for a second is ridiculous, because he was not getting in the vehicle He refused to cooperate. He had refused to cooperate from the minute they tried to arrest him. He was all over the place and fighting them every step of the way. And he's a big guy. They had a bunch of guys there trying to get him in a vehicle, and they couldn't do it. And then he said, "I want to lay on the ground." They're like, "Okay, fine, we'll get you on the ground because we can't manage you." So to say that is nonsense. And I think, to say that you shouldn't have bothered the man, even though he theoretically passed a check that was money that was counterfeit, and you shouldn't have bothered the man even though he was under the influence of drugs and behind the wheel of a car, and you shouldn't have arrested him, and you shouldn't have tried to put him in your vehicle, and you shouldn't have put him on the ground. These are all things that are ridiculous. The police did what they should have done from the time they arrived. I saw absolutely nothing wrong in all their behaviors at all. Until he gets on the ground, and then we run into some issues. But up until that point, they were nice to Floyd. They were trying to manage him. They were trying to handle him. They were trying to deal with him. And they weren't being mean or anything. When he said, "Oh, I can't get in the car because I can't breathe in the car, I'm claustrophobic," they said, "Well, roll the window down. We'll put the air conditioning on." They went out of their way to try to help him. So I saw no wrong being done there. And I think when the prosecutor says the police were even wrong to basically show up and deal with the public calling them because of a crime, and also preventing a dangerous person, a person who is dangerous behind the wheel, from driving, I think that's outrageous. I mean, I just think that has nothing to do with this case at all. They're trying to make the police look so bad, the prosecutor, from the beginning, that it distorts what the jury thinks, because they're all going, "Oh, those police were so bad," and that poisons your point of view, because you're not looking at the evidence yet. You haven't even looked at the real evidence. What you're doing is poisoning their viewpoint of the participants and the accused. And that is problematic because, again, we're dealing with more emotions than we're dealing with evidence. So let's go on. What else is this? The prosecution is also very clever because he uses the word knee like a gazillion times, along with the 9 minutes and 29 seconds. Knee, 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 knee. As that, the one thing everybody saw was the knee, and he's going to pound that into everybody's head on the jury. You saw the knee. You saw the knee. The knee was on his neck. The knee was on his neck. So again, we're playing with that kind of, the visual, as opposed to what did the knee on the neck mean? What did the knee on the neck do? Because he did have a knee on that area of Floyd's body. So that's not an untruth. But then one has to question what it actually did. Okay, so let's move on. So he talks a lot about Floyd trying to lift up his shoulder and get his ribs off the pavement to breathe better. That's true, but it also proves that had Chauvin really pressed super, super hard down on this area, he wouldn't have been able to get his head up or his shoulder. He would have been stuck down there. So the fact that you see Chauvin's knee go up and down a number of times shows that he wasn't pushing that hard. But yes, Floyd still had his hands behind his back. He's still in an uncomfortable position on the pavement, and he still had somebody. I think there was like a knee to the lower part of his back. It looked lower to me, but it may not have been. It's not quite clear. So he was being restrained, prone. There's no question about that. But I did not see that the pressure on his neck was that extreme, and so again, that doesn't really hold true. Okay, then he goes on about this. He talks about how people were freaked out by what they saw, and that they called the police because they were so upset and they wanted to testify. Totally irrelevant. Totally irrelevant. Because we have a video of the actual incident that happened quite much from the beginning to the end. We have cameras that were at the store. We have cameras on the street. We have cameras on the police. We have cameras in people's phones. That is one of the most videographed incidents I've ever seen, from beginning to end. So really, you don't need your opinion that much. So what we have is the prosecutor is going to bring in all the witnesses for emotional purposes. It was just a horrible thing I saw. I couldn't believe it. He was just dying in front of me. He was just dying in front of me. That's emotions. That's not evidence. And personally, I don't care what any of those people have to say, quite frankly, because it's not the evidence, but it will influence the jury. And it's allowed in the courtroom, apparently. So the prosecutor is going to use it because he wants to make sure the jury, feels that kind of emotion as well, that this was so horrific, and everybody saw what happened. And what people saw happening is not necessarily exactly what happened. We know witnesses all over the place can see something, but they don't necessarily know the specific details of what happened. And that's what the law is about. And this is what I'll be getting into is the law has to prove what actual actions occurred, actual actions, not what you viewed as an action, the actual action. Okay, now he talks about medical causation, what caused the death of George Floyd. And this is where it really gets kind of complicated. Now, there are some people who said he just died of an overdose of drugs, and that probably is not true. I think they're correct about, the prosecution correct about that, he'd done drugs for a long time. He probably had a pretty big tolerance, and he was a big dude. So that he just died of a drug overdose, just like that, just boom, no. But the problem is he had, and I always have to look over this word because it's this agitated delirium. I just have trouble saying it. Agitated delirium. And this is something he totally exhibited. And this comes from taking drugs like methamphetamines. And when a person has agitated delirium, it causes a whole bunch of things. Paranoia, it causes sweating. It causes very strong abilities to move around. I mean, just incredible physical strength. It causes massive agitation, and it causes heart arrhythmias. It has all kinds of effects on your body. And guess what? If you have agitated delirium, you can die of the agitated delirium without anybody putting you on the ground and putting the handcuffs on you and keeping you in a prone position. You can die of that. So that's an interesting point because they're in the autopsy. They try to say that, let me read what the manner of death, he said, is homicide, deaths at the hands of another. Not necessarily proven at this point. And that's what supposedly it is, but that's not necessarily proven. Now, he's saying here that the cause of death, here it is. The cause of death was cardiopulmonary arrest, complicating law enforcement, I don't know what word it is, restraint and neck compression, and also being pressed down on the back so he had less ability to breathe. Now, here's the problem. There was no physical evidence that there was asphyxia. Asphyxia meaning like if you press really hard on the neck, you can cause a carotid artery. It can block the blood from going back to your brain, and eventually you won't have enough oxygen and you will die. That's how a lot of people hang themselves that way. They don't actually jump off a chair and choke to death. They just bend their knees and have something press on the side, like a belt or a rope presses on the side of the neck, and then they go, oh, I kind of feel kind of zippy, and then they pass out. And since their knees are bent and they're unconscious, they can't push back up to get the blood running again. That's how they die. But that's not how there was no evidence of that. There's no evidence that anything was crushed. There was no evidence of any kind of damage to anything around his neck. There was just no evidence that he was choked to death or he was crushed to death like the prosecutor's trying to say. That there's not evidence of that. What there is evidence of is the agitated delirium. He definitely had that. And interesting to me is this. When he was standing up, before he was getting into the vehicle, he said, I'm going to die. I'm going to die. I can't breathe. He said he couldn't breathe before he hit the ground. Now, this is another whole quagmire, actually. I believe he was having problems breathing, and I believe it's because his things were failing from the agitated delirium. But if you've been a police officer, pretty much every time you put a guy in the vehicle, they say they can't breathe. Every time you try to put handcuffs on, they say they can't breathe. They say the handcuffs are too tight. I can't breathe. The handcuffs are too tight. I can't breathe. This is so common that, unfortunately, somebody who's been on the force 17 years, they may have just gotten to the point where they just pay no attention to that anymore. Yeah, you can breathe. You can talk. And he said that. If you can talk, you can breathe. And, to some extent, there's truth because you're not actually choking. You can get air in, but the problem is your lungs and your heart just aren't working well enough. So you're breathing, but just if it's not as good as it should be, and eventually you just don't get enough oxygen and then you collapse. But I mean, a lot of people say that anyway. I mean, I can't breathe. I can't breathe. I mean, that happens all the time. But in this particular instance, he was saying he couldn't breathe while he was standing up before he hit the ground. So, and when he was hit the ground, he kept saying the same things. And the thing is, he was speaking. So we're not talking about somebody who can't get the words out. So to me, this compression thing wasn't really happening to the point where he was suffocating, or he had, that's just not happening. So he was failing from here down, not in here. So the fact that there was a knee on his head really is fairly meaningless. And the carotid artery wasn't being constricted. So the problem wasn't from here up. The problem was in his lungs and heart. Now, the complicated part, and I'll get to that complicated part. Oh, well, I just want to stop to say, you'll hear George, this is what the prosecutor says, you'll hear George Floyd being terrified of getting into the car and says he's going to die. Then he's manhandled and he freaks out. Well, he wasn't manhandled. He refused to get in the car. He's not cooperating. And it's not the police's fault that he's terrified of getting into the car. And he says he's going to die because he's getting into a car. Now, if he had gotten into the car, he wouldn't have been in a prone position, so that wouldn't have happened. And it's also possible he could have just died in the car from the same problem, that he had the agitated delirium, and he was dying from that. So he would have died naturally in the car from the drugs in his system, or he would have not died in the car. But he kept saying it's not the police's fault. He wants to shriek that he's terrified of getting in the car, and that he's going to die. And he's standing up doing that, and the police aren't doing anything to him. Then he says he's manhandled. Well, if you're going to fight the police and you won't get in the car, you're going to be manhandled. That is a requirement of the police, to manhandle you under those conditions. They can't go, okay, we'll just step back and you do what you want, George. You can't do that. I mean, this is ridiculous. This is saying police shouldn't even do their job. He's supposed to get into the vehicle. They were going to roll the window down, put the air conditioning on. All you have to do is sit in the vehicle, George. And he wouldn't do it. Maybe at that point, and this is what my feeling is, the agitated delirium started having that effect on him. He started feeling something was severely wrong. I mean, he could feel, you feel like things are just caving in on you. And he's also paranoid from the drugs and everything else. So, it's hard to know what was really happening and what he imagined was happening. But he felt a sense of doom. And a lot of people, when they're about to die, do feel a sense of doom. So I think probably it's already having failing issues when he was standing up. Can't prove that, right? That's not provable. But I mean, there are the things he exhibited, and the fact that he had heart problems, which contributes to this as well. And he's on the drugs, which contributes to that. There's these things that cause more of the agitated delirium to be, something that's going to be fatal. And in this particular case, the incident turned out to be fatal. The question is, what actually caused his death? Was it the agitated delirium that had nothing to do with the police? Or was it being put on the ground prone and having and I don't believe it has anything to do with his neck, being held down prone on his stomach, where he had less ability to move his lungs in and out quite as much. And here's the problem with this whole situation. If he didn't have agitated delirium, he may not have died from being prone on the ground. But more people die when they have agitated delirium if they're prone on the ground. In other words, they're already in trouble, and being put on the ground is more trouble. Now, supposedly, this is being taught. One of the education things that the police officers are supposed to get, that they're being taught that a person in agitated delirium will have more chance of dying in a prone position than a person who doesn't have agitated delirium. I don't know if Chauvin got that particular class. If he did, then he should have known it. But if he didn't, he may not have even thought about it. He might have said, okay, we just got to get this guy on the ground. He wasn't thinking that particular maneuver would necessarily cause a death of somebody in George Floyd's condition. And there has to be an intent there. He has to say, well, I know that'll cause his death. I'm going to shove him on the ground and make it worse. So I don't know. We have to prove that his actions caused the death of George Floyd. And then the prosecution has to prove that he had an intent as well. It depends which charges you're looking at, but you have to prove these things with the evidence. So far, what do we have? Let's just like what we've got now so far, and what the prosecutor said is the police shouldn't have even bothered with him. The police shouldn't have manhandled him and tried to put him in the car. And the police shouldn't have put him on the ground and in a prone position. And that's probably the only part I think has some merit to it. And maybe that is true. They shouldn't have been in a prone position. Now, let me step back. There are reasons to put somebody in a prone position. What are they? That you can't handle them in any other way, that they're so big, they're kicking, they're doing all kinds of things, and you have to get them down, even if they have cuffs on, because you can't manage them. And a big, huge guy like George Floyd, he was fighting with everybody, and it was as many cops as they had there, they were having trouble controlling him. And the only way they got control of him was in the prone position and with a knee here and a knee there. So I can't say for sure, and I don't know if they're going to get their witnesses in to say whether that they had to go there or they didn't have to go there. It's not the best choice for many situations, but on certain situations, that is the only choice you have. Now, that question then comes, how long should a person be left in the prone position? And theoretically, it's till you get control of them and until they stop fighting you. Now, I do know there was some level of him kicking and still moving up and down. So he was, at that point, to some extent, still fighting. And so that's why if he can keep going up and down, you're still fighting. He thought, stop fighting. Well, he eventually did stop fighting, and then he died. So the question is, I don't know, because I'm not a police officer. So this would be something, again, the defense might have to bring into court, bring in lots of police officers and say, look, usually what happens is to put them prone on the ground. They fight, and then they stop moving. They go, okay. And they just lay there. And we've just assumed they're just laying there now because they've stopped fighting. They're just laying there because they're okay. I don't know. And I don't know if that's what's in Chauvin's mind. He's like, oh, finally the dude stopped fighting, or whether he just didn't care, or he's callous about it. It's like, okay, whatever. He's on drugs and he's fought us, and now, he's fought, and now he's stopped. And, I guess whatever happens, we got an ambulance on the way. Called the ambulance, which you're supposed to do, by the way, when a person has this agitated delirium problem. When you have any kind of injury, when you have any, obviously if you stop breathing, the ambulance is supposed to come, and the ambulance was coming. So that part was done correctly. Now, so let's see what else is in here before I go to the one that really I think is the issue. And to me, okay, if unconsciousness occurs, you're supposed to immediately call, and they did call. So that was not the issue. And also, by the way, after a violent struggle, you can have a cardiac arrhythmia and a cardiac arrest after a violent struggle. Again, and he was struggling. So we're still back in that agitated delirium could have caused his actual collapse, and not necessarily the prone position, but they could have also come together. One was exacerbated by the other. Now, here is the issue that I would say that the defense is going to have a problem with. And the defense came out and just said, use common sense. But I say this is not such an easy case. Now, here is the difficulty. And here's the one place which I go, maybe you should have. Now, he was in a prone position for quite a while, as the prosecution says, 9 minutes and 29 seconds. Okay. If he wasn't being held super tightly in that position, he was moving around, perhaps the prone position wasn't causing him that much damage for a number of minutes. I don't know. And we don't even know if the prone position caused him to die. We don't know if it's just the agitated, I always have to look at that, I can't say it, agitated delirium, it doesn't stick in my head. Agitated delirium was already killing him before he got to the ground, and this was just, he would have died anyway, even if he'd been sitting up or in the car. Don't know if the prone position caused his death, contributed to his death, or had nothing to do with his death. Three things. Let's look at it again. I don't know if the prone position caused his death, contributed to his death, or had nothing to do with his death. And here's the problem. The autopsy proved nothing as far as how he died outside of his heart stopped. There is not proof that he was asphyxiated by Chauvin. There is no proof of that. He might have died from positional asphyxiation from the prone position, but there's no physical evidence of that because usually there isn't. So it's mostly circumstantial. And you put all the totality of the evidence together and you say, it likely could be this. But here's the problem. You have to prove it theoretically. I mean, well, not theoretically. In a courtroom, you have to prove that the action was the cause of death. And in this particular case, there is no proof that the prone position caused George Floyd's death. Now, at the moment he stopped moving, which could have been caused by, say, just the agitated delirium and his heart giving out and that situation, he died. We know he died. He stopped breathing. Okay. We don't know the exact cause. All right. So now he stopped breathing. Now, at that point, a lot of people say, why did Chauvin not then take his knee off of him and roll him over, check his pulse, and put him in a better position just in case? That's a good question. And I think the defense is going to have to deal with that a lot because that shows there's a number of possibilities that they're going to throw out there. The prosecution is going to say he was callous and didn't care about George Floyd and didn't protect the person he's supposed to protect because he's protecting and serving the community. And even when you're arresting somebody, they're in your care and you're required to protect them and take care of them, even if they're doing bad things. So why didn't he just let up at that moment and say, hey, roll him over? As a matter of fact, one of the other officers said, hey, shouldn't we roll him over? And Chauvin said, no, the ambulance is coming. Why didn't he do that? Was it because he just figured, well, he's dead, or he's probably not, well, the ambulance will be here in a minute and they'll take care of it. He was distracted by the crowd. He was just, watching everybody and just said, okay, I hear the ambulance is going to be here and I'll just let him, the crowd's here. I don't want to do anything right now. I'm just going to stay in position. I don't know the thoughts that went through Chauvin's head at that time. Do I think, looking at it, I didn't come off real well. I can say that. It probably would have behooved him to actually take his knee away and roll over Floyd and check on him. And I don't know about the issue of CPR under those circumstances, why, that wasn't given, or whether there's some reason you're just going to wait another minute for the ambulance to show up. But here's the thing. If George Floyd if Chauvin didn't cause the death of George Floyd, a provable cause, if there's no physical proof that Chauvin's knee and restraint caused the death of George Floyd, then you can't get him for homicide. You can't because it's not homicide is the death at the hands of another. And if he didn't actually cause the death, if George Floyd died of that agitated delirium, oh, look, I didn't look over at the note, agitated delirium and not necessarily the prone thing, then Chauvin is not guilty of killing him. If the position did contribute, then you could say there were contributing factors and Chauvin's choice to do that. And, then you could say there's something there. Then you could say, yes, he's, you could charge him with homicide. But as far as I can see, the prosecution basically saying there isn't any proof already of that. There's no physical proof. It's just circumstantial. Well, it looked like he was being held down, and that could have means nothing. Could have means absolutely nothing. You have to have proof that it did. So far, what I see is that the agitated delirium already started when he was on his feet, and it was maybe exacerbated by the prone position, but we do not even know that. So I don't see at this point that the evidence supports that there's Derek Chauvin committed a homicide. Now, some other issues might come up about why he didn't decide to roll him over and check on him and give him CPR. And I think the prosecution might try to push that. Maybe he could have saved his life and therefore committed homicide by not trying to bring him back to life. I mean, you can't really say that. I mean, you can't say somebody died by other causes, but because you didn't give him CPR, you're guilty of homicide. You can't really say that. You can just say, maybe you should have done something, maybe unethical, maybe immoral, and maybe you shouldn't be a police officer. Maybe you should, there's a lot, maybe you could be charged with some lesser thing for that. But if you can't prove that the person their actions actually caused the death of someone, then you can't charge them with homicide. Well, you can charge them, but you shouldn't find them guilty of homicide. So I think it's going to be an interesting case, because I don't know what they're going to bring to the table that is proof. Let me just say what the defense attorney just didn't say much. I mean, really, oh my God, it was just terrible. He just came out and basically said, use common sense. And that was it. So the prosecutor did a 10 times better job than the defense attorney as far as what the jury sees. I already see that I'm not seeing proof of the cause of death. We don't even really have the cause of death is heart failed, but it wasn't asphyxia. That's not proven. So it's possibly from the positional asphyxiation, possibly, but there's no proof. So I don't see how one can find Derek Chauvin guilty of homicide at this point, because there's no evidence that supports that his exact actions caused the death of George Floyd. Now, I say there might be some other issues that he could be charged with, and that's going to be that's more complicated. I'm just looking at the homicide issue, because that's my thing. It's homicide, and not all the other details of the laws and what you can charge people with. Leave that to the lawyers and the court system. But what they're going to bring. So I want to know what they're going to bring to the table in this trial. What is the prosecution going to do to prove that Derek Chauvin's actions killed George Floyd? And I want to know what the defense is going to do. I hope that I hope they do a better job than they did today. But I think what's going to happen is it's going to be an emotion fest. It's going to be an absolute emotion fest, because I've already seen that the prosecutor came out with every kind of vivid look at this, look at that, and how horrible the police are in general, and oh my God. And so I think the jury they'd have to bypass their emotions and focus on the actual evidence and understand what homicide means and what cause of death means and what actions causing homicide mean. And if they can't get past that and they go with the emotions, or they go with I want to be able to walk the streets and not get beat up, they may come to a decision that's not based on evidence. I'm not saying I know what I would do if I were on that jury at this point in time, because I haven't heard all the evidence. I'm saying from this just today, I'm not seeing any evidence that absolutely supports that Derek Chauvin's actions caused the death of George Floyd. That's all I can say. Maybe something will come up in the court that we don't know about, but between basically the autopsy and how things work as far as agitated deliriums and his health conditions and the drugs that were in the system and the position, I don't see it's there. So I'll be interested. Please write in your comments, what you think about the issue of is so far is the case strong that Derek Chauvin caused the death of George Floyd? Is there proof that he caused the death of George Floyd? So I'll be back later after we know a little bit more, when we see more of the hopefully some evidence come out that then we can support one thing or the other. But so I'll be back to talk more about this case. But I just wanted today to share with you what I saw they presented today, which was pretty limited. But the prosecutor, in my opinion, didn't make the case that Derek Chauvin his actions caused the death of George Floyd. And the defense didn't make any case at all. So, I mean, so we'll see what happens. And we'll see you next time with some more thoughts on the case. Good night.